What if the patent you're relying on or fighting against was never supposed to exist in the first place? A validity or invalidity search is a stress test for a patent. It goes far beyond a routine check and asks a single, critical question. Does this patent truly deserve the monopoly it was granted? In this video, we'll explain what validity and invalidity searches really are, why they matter in lawsuits, negotiations, and acquisitions, and how they can completely change the balance of power in high-stakes IP decisions. A validity or invalidity search is a stress test for a patent. It is a deep dive investigation to determine if a patent that has already been granted actually deserves to be a patent. First, it is essential to clarify that validity and invalidity searches are, in fact, the same process. You are searching for prior art documents, products, or public knowledge that existed before the patent was filed to find out if the invention was truly new and non-obvious. The only difference is who is asking and what they hope to find. Invalidity search. You are the attacker. You want to find evidence that the patent is weak so you can kill it. Validity search. You are the patent owner or a potential buyer. You want to find that same evidence first to see if your shield has cracks in it before you go into battle. To understand this search, you have to look at the motivations behind it. It usually happens in three specific scenarios. First, the lawsuit. Imagine you run a tech company and a competitor sues you, claiming your new product infringes on their patent. You are now the defendant. Instead of just saying, "No, I didn't copy you," you go on the offensive. You hire a firm to conduct an invalidity search on their patent. Your goal is to find evidence before the filing or priority date of the patent that perfectly describes their invention. If you find it, you can show it to the court and say, "Your Honor, this patent should never have been granted in the first place because this technology was already old news." If the judge agrees, the patent is invalidated and the lawsuit against you is dismissed. Second, the negotiation. Now, imagine you are the patent owner. You want to license your technology to a prominent manufacturer. Before you walk into that boardroom and demand $1 million, you need to be sure your patent is bulletproof. You commission a validity search on yourself. You want to see if there is any dirt out there that the manufacturer's lawyers might find. If the search comes up clean, you can negotiate with confidence. If the search finds damaging prior art, you might lower your asking price or fix your strategy so you don't get embarrassed during negotiations. Third, the purchase. A company is buying a startup for $50 million, mainly because the startup owns a revolutionary battery patent. Before writing the check, the buyer runs a validity search. They need to know, is this asset actually worth $50 million, or is it a worthless piece of paper that will fall apart the moment someone challenges it? But how exactly does a validity search work? When the patent office initially granted the patent, the examiner had a limited time, often just a few hours, to search for previous inventions. They may miss things. The validity/invalidity searcher has weeks or months to look where the examiner didn't. They look for obscure technical manuals. Maybe a 1980s user manual for a washing machine describes the mechanism. Foreign patents. An invention might be new in the US, but it might have been patented in Japan or Germany in the 90s. NPL, non-patent literature. PhD theses, conference papers, or old trade magazines. The searcher is looking for a date. If the patent was filed on January 1st, 2015, the searcher is desperate to find a document published on December 31st, 2014, or earlier that describes the exact same features. If they find it, the patent's claim to novelty is destroyed. The final result isn't just a list of links. It is a legal weapon called a claim chart. This is a document that breaks the patent down sentence by sentence claim 1, claim 2, etc., and places it side by side with the text from the old documents found. If the chart matches up perfectly, the patent is in trouble. At its core, a validity or invalidity search is about leverage. If you're challenging a patent, it's how monopolies are dismantled. If you own one, it's how you avoid being blindsided when it matters most. Whether you're facing litigation, negotiating a license, or evaluating an acquisition, understanding the real strength of a patent can be the difference between control and exposure. Whether you're defending, negotiating, or investing in patents, understanding their true strength is critical. Follow us for more insights on IP strategy, patent risk, and value creation.